law professor here at UMKC Law. And he received his JD from Stanford University Law School, and his undergraduate from Gustavus Adolphus College, I hope I pronounced that right, in St. Peter, Minnesota. Got a math degree, and I always like to visit with my fellow math majors. Maybe we can discuss our fond memories of differential equations after the presentation. In addition to teaching constitutional law, Professor Linder teaches the jury practice and perspectives seminar in famous trials, communications law, and First Amendment law. Professor Linder has been honored numerous times here at the law school and his other working positions that he's had at Indiana University and the University of Iowa. And I'm not going to mention the name of his constitutional law successor here at the law school because I think Professor Linder will give a much more reasoned and accurate analysis of the Supreme Court. So with that, I'd like to turn the program over to Professor Linder.
Reasoned and accurate. Thank you, Lynn. Thank you, Stan. And pleasure to be here tonight. And we have a mix of people in the audience. I know we have some with the Americans United group, and we have some students satisfying a snow day option here tonight, and probably some others as well who just kind of wandered in here. We con law profs, as you might know, tend to focus primarily on the Supreme Court. The Supreme Court does quite enough to keep us busy without worrying about everything that's bubbling around in the lower courts. Our rationalization for focusing on that is also that it keeps the big picture in mind. We like to not lose sight of the forest because of the trees. Although, if you have questions about some of the trees, some of those lower court decisions that are out there, some of the issues that are starting to come through the court system, I'll try and leave a little time at the end of the talk to address those. And so my plan today is kind of take a tour of where the Supreme Court stands today in the area of church-state relations. We can't look at every topic under that big umbrella, but we'll look at several that I think will point us towards what really is the center of the court today, where the court is coming down in these cases. Not necessarily where it should be coming down, but where it is coming down, and where it's likely to come down, I think, in the future. We'll talk a little bit about that as well. And I thought I'd start our tour today by looking at a topic that's occupied the court for the better part of 3 decades now. There's been a rather flurry of activity in this area, a dozen or so cases involving religious displays of various sorts on public land or in public buildings. So where is the court on this particular topic? And we can start our tour with display that has not been challenged under Establishment Clause grounds, the pink flamingos with the Santa Claus hats. No one, I would think, would argue that that's a violation of the Establishment Clause. It clearly does not primarily exist to serve some sort of religious purpose. It doesn't have a primary religious effect, and even liberal justice on the Supreme Court would probably say just fine. However, when we turn from that situation, which clearly is simply a celebration of the season and no one can have a problem with it, something a little bit more problematic, such as this particular display, which is a display that existed in Pawtucket, Rhode Island in 1984. And you can see it looks like a very traditional nativity scene there. You find baby Jesus surrounded by Mary and Joseph, a couple of sheep, looks like a shepherd or two, and then 3 wise men. Assume, looking at that particular display, that would raise some serious issues under the Establishment Clause, and it certainly did and was challenged. However, on a 5-4 vote, the Supreme Court decided that that particular display was okay. Why was it okay? Well, who or what saved it? The answer is Santa Claus saved it, or the reindeer, I'm not sure which. But what happened in Pawtucket was that in addition to having this nativity scene up, in the same general public square, they had Santa Claus, some reindeer, a Santa Claus house, a dancing plastic elephant, carolers, a candy-striped pole, and I think Frosty the Snowman. And the Supreme Court looked at the overall
public square and said, you know, taken together, given the fact that there were all these other sort of Christmas things around, the primary effect of that display was not one to sort of convey religious endorsement. Justice O'Connor was the key vote in that case, and she thought that the reasonable observer, given the whole display that existed there in Pawtucket, would not say that was an endorsement of religion. That was her view, and she was the key vote, right? 5-4 vote, and for a period of quite a long time, Justice O'Connor was the swing vote. What she said is what the law was. Coming out of that case, people, cynics, I guess, for the most part, said, there's a 2 plastic animal rule. As long as you've got 2 plastic animals, you're okay. And that principle was quickly applied in other contexts as well. Christmas programs or winter programs, whatever they were called. It's okay to have Silent Night in a little town of Bethlehem so long as you don't forget Deck the Halls with Bells of Holly, right? So if you've got some secular seasonal songs along with some religious songs, then it's okay. If it's purely religious, you've probably got a problem. That seemed to be the message coming out of the Pawtucket case in churches. So